Number 104, the people of the state of New York versus Stephen Baisley. Thank you. Counsel?
Good afternoon, Your Honors. Richard Hirschfeld for the appellant. If permissible, I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Thank you. The appeal brings before this court the question of whether the language
Counsel, did the underlying support order originate family court? Is it a family court order or is it a Supreme Court order?
It's a Supreme Court order. I was mistaken about that, and I apologize.
Okay. So then can you please clarify how we're able to actually address your challenge if your challenge is grounded on these orders out of the family court, and this is an order that comes out of Supreme Court?
There should be no difference in the analysis. The Family Court Act provides for exclusive jurisdiction concurrent with the Supreme Court. The best analogy I can give you would be the older version of the Family Offense Act, where it was exclusive to the family court, and then ultimately the legislature changed it to be concurrent with the criminal court.
But that doesn't limit Supreme Court to family court's jurisdiction, right?
No, but
In
it
other
does.
words, Supreme Court doesn't have exclusive original jurisdiction.
No, but what the Family Court Act says is that support matters come to the family court as an exclusive matter under Article 4, but it does not limit the Supreme Court in its concurrent jurisdiction. So the Supreme Court had jurisdiction to address and provide for this support order, but that did not give the criminal court jurisdiction to proceed on the enforcement of that order.
Can someone be prosecuted for violation of 260.05 of the penal law if there's never been a child support order?
Under 260?
260.05, yep.
I believe subsection A allows for that, if I'm not mistaken. Subsection B provides for non-payment if there is a family court order, and subsection A if that does not require an actual order.
So what's the purpose of subsection B?
What's the purpose? I knew I was going to be asked that question in terms of reconciling it with my argument that
Doesn't it render it completely meaningless?
I don't have a good answer for that, Your Honor, other than the language of the Family Court Act speaks to exclusive jurisdiction.
Well, let's talk to the language of the Family Court Act. Doesn't the language of the Family Court Act say that the family court has exclusive jurisdiction over support proceedings under Article 4?
Yes.
Okay. And Article 4, right, talks about establishing an initial amount of support, right? And it talks about modifying support orders. And it talks about enforcing those orders to make sure that the payor continues to make payments or resumes making payments. Isn't that essentially what Article 4, and there's also Article 5B, but I don't think we're talking about
I'm not sure if you're driving at it, but the enforcement...
Well, what I'm driving at is that it's what is in Article 4 is not necessarily the same as what is in the criminal procedure law. The criminal procedure law has criminal liability, has different purposes and different remedies and all sorts of things. So why is one exclusive of the other?
Well, because the legislature said so. Because the legislature said that any matters of support under Article 4 is exclusive to the family court with concurrent Supreme Court jurisdiction.
Right. So
And what it does is it provides for enforcement of those orders under 454 and 455 or Domestic Relations Law 245, but gives those courts a tremendous amount of other remedies. And as this court noted in Columbia County versus...
Isn't that all civil enforcement?
It is civil enforcement.
And right, this is not obviously a civil action, right? This is a criminal prosecution.
But again, the question is whether the criminal the criminal court has jurisdiction. I mean, this is the same situation as the court faced back when the Family Offense Act was exclusive to the family court. You still had criminal prosecutions for those acts, but not when they're family offenses.
How about this? Would under your theory, a local criminal court lack jurisdiction to handle an order of protection that had been issued in family court under the family court proceeding under the Family Court Act?
No, I don't believe they would, but there you've got concurrent jurisdiction with the criminal courts, and here you don't. So what you have here is the legislature's recognition that the judges of family court and the judges handling matrimonial matters in Supreme Court have a lot more expertise dealing with whether somebody should be thrown in jail for non-payment or there should be other remedies. As a matter of fact, they can't issue an order of contempt unless and until they find that the other remedies are unavailable.
So how do you square your argument with CPL 10.30 and the fact that that's grounded in the Constitution?
Only, again, the language, I go back to the language of the Family Court Act that says exclusive jurisdiction. And this court's, decision in People versus Johnson, again, dealing with the Family Offense Act, when it was exclusive, exclusive is exclusive. It's given an expansive interpretation. There are cases such as Johnson or Oliver and Jones cited in my brief where there are other issues related to those exclusive areas, but all of them fall within the same concept, the same reason for giving Family Court Act, the Family Court, the first crack at this. If you look at, and what you're looking at here is basically the fortuity of who decides to go to which court, whether you have a fairly humane approach to the issue and still a determination as to whether or not they should be put in jail for the 6 months authorized by these statutes, or in this case, you've got 20 counts.
I'd like to go back for a minute to the Family Court Supreme Court distinction and ask you this question. So my understanding from what I could piece together from the record is that this originated in family court. There was a temporary support order, and then family court realized that there was a contested matrimonial, or maybe the contested matrimonial was commenced after that's not clear, and so they sent the case to Supreme Court. Did family court even have jurisdiction to issue the order that Supreme Court ultimately issued in this case? So I'm not sure that this was ever so there was a temporary order and then there was a permanent order. And the permanent order was clearly an order of the Supreme Court, I think, in a contested matrimonial. That is something over which family court has no jurisdiction at all under the Family Court Act. So I'm sort of getting back to the fact that it was a Supreme Court order. To me, it seems like it would make a difference as to whether we should be addressing the family court exclusive jurisdiction at all. Do you understand?
I understand what you're saying. Your access to the record was more expansive than mine. I only had the motion papers, which really didn't get into any of that. But
well, the Supreme Court order.
Right, but the Family Court still.
Itself, I assume you had access to the Supreme Court order. That's all I'm referring to.
Right.
Is that order?
But I believe Family Court still has jurisdiction even to enforce non-payment of a Supreme Court order. So whoever decided to bring an action to hold the obligor in contempt or to compel payment could have brought a family court petition to do so based on that Supreme Court order. I don't think family court lacked jurisdiction in that respect.
In going through the papers, it seemed to me that the people's strongest argument was the CPL sections that give local criminal courts express jurisdiction over misdemeanor cases, and it's not restricted in any way. I think it's 1031, and I marked it down 120 sub 24.
But again, even with the unlimited jurisdiction, I still go back to when, the case law we do have when family offenses were exclusive to family court. And those were misdemeanors or possibly even felonies. But the legislature said family court has to have first crack, and that was upheld by this court.
I see. Thank you.
Thank you, counsel. Counsel?
Good afternoon. May it please the court, I'm Andrew Cass. I represent the people in this matter. The appellate term order should be affirmed for the reasons that were stated.
Why doesn't exclusive mean exclusive?
Because the exclusive part there refers to what is a maintenance or support proceeding, a civil proceeding in family court. It makes no reference and cannot make reference to the criminal procedure law and to the jurisdiction that's granted to criminal courts under the criminal procedure law.
It does, I don't remember the languages. Section 411 of the Family Court Act, in the grant of exclusive jurisdiction, does it make reference to support and maintenance proceedings in the statute? If you remember. If you don't, it's all right.
Right, but the thing, I think it comes back to the fact that, plain and simple, as the court is recognizing, that the criminal prosecution is not a support or maintenance proceeding.
I understand that. And the statute in 411 makes specific reference to that, doesn't it?
Well,
I'm throwing you a softball here.
Yes,
You know,
because the other part of it is this. The legislature, if we put aside the question of criminal contempt, in the first place, we start with the non-support of a child, whether it's a misdemeanor or a felony. In this case, it was a misdemeanor. The legislature, so we're not talking about a county law. We're talking about the same legislature that enacted the Family Court Act. And so by definition, by the enactment of that statute, it's conferred criminal jurisdiction. Otherwise, you would have a statute that would be rendered meaningless. Also because, and I took a second look, when we look at where there is concurrent jurisdiction for the enumerated family offenses, neither non-support nor criminal contempt are among the crimes that are there.
Counsel, let me ask you,
Yes.
somewhere in the record, there's a reference to a Virginia Circuit Court order. Was that error, or is there some Virginia Circuit Court order lurking in this case somewhere?
To be fair, Your Honor, I just don't have any recollection of that. So I don't want to speculate. It's possible that somewhere that in their family background, maybe there were things that occurred outside of New York State, but I can't be sure. But what we do know is that at some point that Supreme Court Orange County had jurisdiction. And
Okay,
that's
so now
the order.
let me ask that.
Yes.
Let go back to the first set of questions I was asking. Counsel, how can we even address this question if the underlying support order comes out of Supreme Court in a contested matrimonial proceeding, as Judge Stein has already pointed out?
I think there is a fair view that ultimately, as to this case, that it would amount to an advisory opinion. And also, I do apologize for not having caught that at the leave conference. It was asked, and both counsel were apparently mistaken, including myself, on that. So that question is there. Basically, it's ultimately advisory, because if this is a Supreme Court order, Supreme Court is a court of general jurisdiction, and we also know that because when they created the domestic violence parts, as well as the court merger, the court specifically noted that it was done in Supreme Court to avoid jurisdictional issues that might occur between a transfer of a criminal court case.
Well, what about the argument that, at the very least, family court could still enforce that Supreme Court order, and therefore we're back to the merits question?
It's assuming that to be the case. We're not talking about enforcement action. How do we know that? The criminal court has no authority to modify or alter the underlying support order, would have no authority to demand or come up with a compliance schedule, and we're also would have no ability to look as far as a prospective order, looking into the future, how far to extend the order, whether it would be on a sliding scale, modifying payments over time. We're looking solely at past conduct. And so that we know it's not a enforcement proceeding within the understanding of a maintenance or support proceeding. It also, even in the criminal contempt field, serves a different purpose in terms of a public concern, in terms of deterrence, and other things that are more typically supported by the penal law system, as opposed to family court.
And there's some of that in the legislative history, right? As to the reasons for enacting, for example, 260.05.
Correct. Otherwise, the legislature would not have enacted that statute. It would have, the legislature, in its wisdom, could have determined that there was no need or there was no stronger public policy interest for such a statute.
Let me ask you this. If we were to agree that the order should be affirmed, do we have to remit back to the town justice court to decide the branches of the motion that it never decided in the first instance?
That's what would occur here because there were undecided questions.
Branches of the motion to dismiss, other grounds.
That would be a fair thing because there's also questions of, for example, there was a motion to dismiss for facial insufficiency, but it may be a hearsay versus a jurisdictional defect. So the trial court hasn't had an
ruled on any of
opportunity
those,
to rule on that.
Thank you, counsel.
Thank you, Your Honors.
Counsel?
Very briefly, respondent argues that this is not enforcement, but as I argued before, the exclusive jurisdiction section should be read expansively, and the bottom line is this is a non-payment of support. That's what's underlying all of these charges. And the Family Court Act specifically says that for matters of support under Article 4, and 454 and 455 deal with non-payment of support under Article 4, Family Court and Supreme Court have exclusive jurisdiction. This court in Columbia County versus Risley, which is cited in my brief, noted the Family Court's ability to prevent lengthy incarceration for non-payer obligors. And look at what you're facing here. You've got 20 counts.
But the legislature was certainly aware of that when it enacted 260.05.
Yes,
right?
yes, they were. Just to finish, you've got 20 counts. In theory, since they're paired up, I suppose you could have 10 consecutive one-year sentences. So you're looking at...
You max out at 2 under the penal law. But
I'm sorry?
you max out at 2 under the penal
thank
law.
you. Okay, so
But,
2 year...
That's okay.
Potentially 2-year sentence for simply non-payment of support. Thank you.
Thank you, counsel.